And we'll now call our first panel of witnesses for this morning's hearing, Judge Patricia Jonas, the Appellate Operations Executive Director and Deputy Chair of the Appeals Council at the Office of Disability Adjudication and Review of the Social Security Administration, and Dr. Deborah Bice, Chief Administrative Law Judge at the Office of Disability Adjudication and Review of the Social Security Administration. We appreciate both of you being with us this morning. We look forward to your testimony. Pursuant to our rules, all witnesses who testify before the subcommittee are required to be sworn, and at this time I'd ask you both to please stand and raise your right hand. Do you swear that the testimony that you will give before us today will be the truth, the whole truth, and nothing but the truth, so help you God? We'll be using a timing system today. 1 minute before a red light comes on, you'll see the lights change from green to yellow. That'll give you an opportunity to conclude your remarks. Your written testimony will be printed in the record in its entirety. Please limit your oral testimony to no more than 7 minutes. Judge Jonas, we're going to have you go first, followed by Judge Bice. And then after we've heard your testimony, we'll turn to questions. So please, Judge, proceed.
Chairman Levin, Ranking Member Coburn, and members of the subcommittee, thank you for the opportunity to appear before you today. My name is Judge Patricia Jonas. I am the Executive Director of the Office of Appellate Operations and the Deputy Chair of the Appeals Council for our Office of Disability Adjudication and Review. Since 1940, the Appeals Council has helped oversee the hearings process by reviewing hearing procedures and decisions. I oversee approximately 75 administrative appeals judges who review a portion of our administrative law judges' allowances and denials. Prior to Commissioner Astru's arrival, we had performed very little quality review at ODAR. This was due to several years of litigation and congressional reaction to the Bellman Review in the 1980s and budget shortfalls. As a result of that litigation and congressional reaction, our policy guidance and feedback to our ALJs was very limited. In fact, for many years, a remand order was the primary feedback from the Appeals Council to ALJs. While this method of feedback and guidance to ALJs is still an appropriate mechanism to address individual cases, it has limitations. For example, the number of remands to any ALJ is relatively small, and it was generally limited to unfavorable decisions. Today, however, we are better leveraging the Appeals Council's unique position, our General Counsel's office, and the federal courts to provide better feedback. The key, as Commissioner Astru advocated, was to institute a more balanced quality review into the hearings process. First, we developed serious data collection and management information for ODAR, and then we developed an electronic policy compliance system for the Appeals Council. These new tools permitted the Council to capture a significant amount of structured data about the application of agency policy in hearing decisions. In 2010, our Office of Quality Performance instituted an independent national review of hearings decisions to ensure a consistent and comparative review for all 3 adjudicative levels of our disability process. In 2009, Commissioner Astru reestablished the quality review function in the Appeals Council, known as the Division of Quality, that reintroduced a sample review of favorable hearing decisions. It took nearly a year to fully implement this office because we had to hire, train, and obtain office space for about 50 staff to review hearing decisions to identify quality issues. In September 2010, the Division of Quality began reviewing favorable decisions. These new quality initiatives have improved our feedback and policy guidance. The data we've collected identify the most error-prone provisions of law and regulation and help us better train our ALJs, which include annual judicial training and mandatory quarterly training for all ALJs. We also recently implemented a new process that expands the opportunity for ALJs to provide feedback to the Appeals Council on its remands. Improved communication increases consistency. We also provide feedback on decisional quality, giving adjudicators real-time access to their remand data. We provide specific training that focuses on the most error-prone issues. In addition, we provide individualized training as needed. In 2011, the Graduate School USA recognized our government-leading training model with the prestigious W. Edwards Deming Training Award. These efforts are testing some long-standing traditions within ODAR. We are moving from training based primarily on anecdotal information to using data to identify issues. We develop training to refresh ALJs on policy and offer skill-based training to improve the adjudicator's efficiency and accuracy. At the same time, we share this information so that the ALJs can more readily use it. Increased feedback and communication is improving our hearings process. Of course, opportunities for continued improvement remain. I understand the subcommittee is releasing the report on 300 disability cases. We recognize that the sample of cases selected for the report will limit the ability to generalize conclusions from this study. But that said, we believe that the report highlights the same concerns we've already identified, and we hope to work with you on further improvements to this vitally important program. While my office has not yet reviewed the 300 disability cases provided the subcommittee, the agency's Office of Medical and Vocational Expertise did a basic review. I understand that they found a number of policy issues that are consistent with what we saw when the Division of Quality conducted a national random sample review of favorable hearing decisions in FY 2011. Two areas of concern were the evaluation of medical opinion and the assessment of residual functional capacity. Based on data from this review, we provided mandatory training to all ALJs on RFC and evaluation of medical source opinion. Just as with the cases we see at the Appeals Council, the majority of the ALJs in the cases the subcommittee requested appear to have complied with our policies. However, there are examples in which ALJs were not policy compliant in evaluating the appropriate weight given to a medical source's opinion and in assessing the claimant's residual functional capacity. There were also several case examples from one ALJ in which the written decision appeared inaccurate and contained boilerplate information that was not relevant to the individual claimant. The Division of Quality had identified the same issue in the random sample review, and as a result, the Chief ALJ instructed the ALJ to discontinue this practice. This example shows that our improvements are producing positive results, and we are committed to continuing our progress in this area. Finally, to guide our ongoing quality improvement efforts, we have partnered with the Administrative Conference of the United States. Later this year, ACUS will issue recommendations on several areas of our hearings process, including the scope and manner of Appeals Council review, the duty of candor and submission of all evidence, and the effect of the treating physician rule on the role of the courts in reviewing our disability decisions. We look forward to ACUS's findings to help us further improve the quality of our hearings and appeals process. Thank you, and I'm happy to answer any questions you may have.
Judge Jonas, Judge Bice.
Chairman Levin, Ranking Member Coburn, and members of the subcommittee, thank you for the opportunity to appear before you today. My name is Judge Deborah Bice, and I serve as the Chief Administrative Law Judge in the Office of Disability Adjudication and Review. I am responsible for overseeing approximately 1,500 administrative law judges. We strive to make the correct decision as early in the disability process as possible so that a person who is eligible for disability benefits receives them in a timely manner. Our administrative review process generally consists of 4 levels: initial determination, reconsideration determination, hearing, and appeal. The provisions in the Social Security Act and regulations have been incorporated into a standardized 5-step process for making disability decisions called the sequential evaluation process. A disability adjudicator must use this process to arrive at fair, legally sufficient, and legally defensible decisions. Since the Social Security Board established the hearings and appeals process in 1940, we have sought to balance the need for accuracy and fairness to the claimant with the need to handle a large volume of claims in an expeditious manner. ALJs decide cases de novo, meaning that they must review cases with fresh eyes and are not bound by the determinations made at the prior levels of the disability process. This is an important principle because a case at the hearings level is often very different from what it was at the initial or reconsideration levels. There may be new evidence for the judge to consider, as well as the testimony of the claimant, medical and vocational experts, and other witnesses at the hearing. In addition, any change in the claimant's vocational profile, such as age, education, or work experience, must be considered. Thus, an ALJ's decision to allow a claim on appeal does not necessarily mean that the earlier determination was incorrect. At one time, there was a common belief within the agency that an ALJ's qualified decisional independence meant that ALJs were independent and not accountable for their conduct and their work. Under Commissioner Astru's leadership, we have held ALJs accountable where the law permits. Fortunately, most ALJs welcome feedback and want to follow policy. The vast majority of issues are resolved informally by hearing office management. When they are not, management has the authority to order an ALJ to take a certain action or explain his or her actions. ALJs rarely fail to comply with these orders. In those rare cases where the ALJ does not comply, we may order counseling or issue a reprimand. However, the law forbids us from taking stronger measures, such as removal or suspension, unless the Merit Systems Protection Board finds that good cause exists. In egregious cases, we have been able to remove ALJs, but only after completing the lengthy MSPB disciplinary process, which can take several years and can consume over $1 million of taxpayer resources. Unlike other civil servants, the ALJs we seek to remove receive their full salary and benefits until the full MSPB sustains the removal. ALJs do not repay that money, even if the MSPB ultimately sustains the disciplinary process, or the disciplinary action. During this period, we place ALJs on administrative leave to protect the public, and they do not hear or decide cases. Thank you, and I'll do my best to answer any questions you may have.
Judge Bice, let's have a 10-minute first round, and we can go back and forth. If you have exhibits there in front of you, I believe. If you look at Exhibit 22, this is a 2001 report from the Division of Quality. And last year, the Social Security Administration set up a new quality review process to examine actions taken by the ALJs in disability cases. If you look at page 2 of that report, it indicates I misspoke. It's Exhibit 22 is a 2011 report from the Division of Quality. So that the page 2 indicates that the quality review looked at 3,692 cases that are effectuated, 2,880 remanded, 665. I'm sorry, let me repeat this. It looked at 3,692 cases. 2,880 were effectuated, 665 remanded, decisions issued on 147. First, Judge Jonas, can you tell us what each of these categories are and what these actions mean?
Thank you, Senator, for the question. On motion, I'm going to begin with on motion for a moment because I think it can be confusing. It's a technical term from the Social Security regulations 404.969. And as you mentioned at the beginning, it's not an indication, a percentage of on motion is not necessarily an indication of error in the outcome of the decision. I think that it can be misconstrued at times. It's more a measure of whether the ALJ followed the agency policy in arriving at the decision. So perhaps it's simpler to think of it as saying that the decision may be premature, that there was some further policy that the ALJ needed to comply with. The regulation 404.969 requires a random sample selection of cases. The number of cases, the 3,692, were the number of cases that were selected from that random sample that the Division of Quality reviewed during the fiscal year. If there was the effectuation means that in the review of that case, they believed that there was, in fact, that the ALJ had complied with the policy. They did not take review of the case and let it go forward for payment. So out of that, 78% of those were felt that they could go forward with payment. They took on motion review for the remands. The 665 means that the cases, when they took on motion review, decided that the case needed to be returned for a hearing or for some further action. In some cases, the Division of Quality could have issued a decision on their own, and that decision category, 147, reflects that. That might be a situation in which the decision itself was correct, but the onset date was in error. And so the Division of Quality has the authority to issue a decision. For those cases in which an attorney advisor issued a decision where the case needed a hearing, it had to be remanded. So 22% reflects the combination of those cases that were remanded and those cases in which the Appeals Council Division of Quality issued their own decision.
Could that decision be to affirm, or was that a decision which would reverse?
When the Division of Quality, in some cases, those decisions were, if they were able to do it without, if they had the information in the record where they could have affirmed, they did. So there were some of those decisions which were denial decisions, some were later onsets, some were to correct the decision itself, so that if a decision was had something inaccurate that would have prevented a continuing disability review at a later time, the Division of Quality issued a corrective decision.
So is it fair to say that about 20 to 22% of the reviewed files contained errors or an inadequate basis for the decision?
That's correct.
Were you surprised by that figure, 22%?
Senator Levin, we reviewed, this last year, we reviewed over 150,000 denial decisions. The main workload of the Appeals Council before this Division of Quality was instituted was the review of denial decisions. And we had seen I'm not going to describe it again as an error rate, but the sort of the equivalent in a denial is a decision to grant review of a case when the claimant is denied and requests review by the Appeals Council. And that runs at about 20% this last year. So it's equivalent.
But were you surprised by the large number, or does that not strike you as a large number?
I think it's of concern.
Percentage, a large percent.
A large percentage. It's very concerning.
On the gridding matter, you've talked about gridding, and Dr. Coburn talked about gridding. These are charts that the grids developed by the SSA for different levels of work with columns for certain characteristics of the person seeking benefits such as age, education, work experience. Are these grids guidance for the decision makers, or are they directions? Are they binding?
The application of the medical vocational guidelines depends on what impairment is coming, what the situation with the claimant's impairments are. If they have exertional limitations only, then those medical vocational guidelines will direct a result. If there is a combination of impairments, both exertional and non-exertional, then those medical vocational guidelines are in fact that. They're a guideline, not a direction.
You think the ALJs know that?
Yes.
They know which are binding and which are guidelines that are not binding?
Yes, sir.
think that's been clear with the ALJ. Okay, I noticed that there's a reduction in the allowances in each of the 4 levels from 2010 and its previous years and 2011. If you look, for instance, at the initial allowance rate, in the 5 years that this chart provides or looks at, it went up from 35% allowances at the lowest level to 37% in 09, then down to 33% in 2011, which was the lowest percent allowed of the 5 years. On reconsideration, the allowance rate was 13%, then 14%, then 13%, and then in 2011 went down to 12%, which may not seem like a lot, but 1% when you're talking about 12 or 13% is a significant change. On hearings, the hearing allowance rate went from 61%, which was steady, this is the ALJ level, for the 4 years before 2011, and then in fiscal year 2011, it dropped to 56%. The allowance rate at the Appeals Council was steady at 2%, but even at the federal court level, it went from 5% to 4% to 3%. So that it would look as though there are fewer disability findings for the applicant in 2011 as a percentage than it was in the previous 4 years. Is that significant, and if so, why?
Senator, I think that there are a variety of factors that go into the outcomes into these percentages. I'm certainly not an expert at the case workload at the initial or the reconsideration levels to give you a clearer understanding of why there has been a reduction. I think there are some issues with regard to the demographics, the type of claims coming forward. In looking at the significant reduction in terms of the ALJ level, I think that there, again, we're seeing cases that different demographics, perhaps younger individuals. Judge Bice, maybe you
I mean, does it show, for
see
instance,
that?
that there's greater care being taken? Is that a reflection, or is it premature to say that? Judge Bice, just perhaps we get your comment, and then
And again,
I'll on Dr. Coburn.
I'm not an expert on that, but I think what Pat was talking about, what Judge Jonas was mentioning, is the change in demographics. And I know when I was hearing cases, I was seeing a lot more younger people applying, or maybe people who had been working and had lost jobs and were also applying. But I also think, and I'm very hopeful, that it is a result of some of the increased efforts we've made on training our judges on our correct policy. As Judge Jonas mentioned, we've started a quarterly training for all of our adjudicators, and we've been hitting some of these most error-prone areas that were identified in her reviews.
Thank you.
Senator Levin, I might supplement this as well. We've had a significant turnover in staff that support the administrative law judges over the last 5 years. And we've had the opportunity to have significant amounts of training for support staff as well as for the administrative law judges. Mm-hmm. I'm cautious about saying that that reduction is the result just of increased quality, but I agree with Judge Bice. I think it's a significant part of this decision.
Thank you. Dr. Coburn.
Thank you. Judge Bice, I just want your opinion on this. Are the rules for determining disability clear enough so that two trained, knowledgeable professionals could look at the same case and come up with the same decision? In other words, how subjective is this? If I went before and had a disability that was borderline, and you had two ALJs looking at it, they all looked at exactly the same information, are they going to come to the same result?
No, and one of our factors is, our qualified decisional independence on the judges. We don't tell the judge how to decide a case, a specific case, or put agency pressure on that. But we all follow the same law, regs, and agency policy. And we've invested a lot of time and effort into training our judges so that they all have that same understanding of the law. And I believe in most cases, the vast majority of our judges do reach the right conclusion. They are very dedicated public servants. They want to apply the law correctly. They follow agency policy. But it's important at the hearing level, you can have a lot of conflicting evidence in the medical evidence, and there really is substantial evidence to support different conflicting results. And so that's the job of the judge. I always tell our judges, don't abdicate your role as a judge. Really develop it, ask those difficult questions, make those difficult decisions. But they need to assess, the credibility of the claimant. This is the first time that anyone is seeing the claimant and talking to the claimant. The claimant's testimony about their subjective symptoms, about their activities of daily living. Sometimes we get new information. So that can make a difference.
So tell me why, what was the reasoning that the Social Security Administration has discontinued the Minnesota Multiphasic Personality Test for use by the ALJs, since it is as a trained medical professional, I know how to use that test, and so do ALJs. Why have they been excluded from using that test?
Senator Coburn, I'd like to get back to you on the record for that. That is really an area for our disability policy people. As judges, we administer the policy that's created, and we have they issued a policy on that, and I'd like to provide that more information to you because while you're a doctor, I'm not.
Well, but does it make sense to limit the ability of ALJs, given that part of their problem is independence, or part of their advantage is truly independence? Why would we limit their ability to use a very well-proven, half-century-old psychological technique to look at? Why would we take that tool away from ALJs? Can you give me any explanation of why you would think that should not be in the armamentarium of a ALJ in assessing a case?
I'm going to defer to our disability policy people and ask to get back to you on the record for that.
Would you make sure that that comes in to me?
I will make sure it does.
Right. Thank you.
Thank you.
We have concluded pretty much what the Social Security Administration has in terms of cases that don't meet the requirements for quality. What are the three biggest problems, Judge Bice, that you see that account for that lack of almost a quarter of the cases don't fit to the parameters of quality in the decisions?
Thank you for the question. Again, this is I think it's important to recognize your cases came from 2006 to 2009.
Yeah.
We've really invested a lot in training. Well, first, I think the first one is the quality review that Judge Jonas spoke about.
Yeah.
We
did have cases in 2010.
Oh, okay. I'm sorry. So 2010. But as Judge Jonas said, it was in 2010 that we were really starting that quality review. I know as a judge, I received very little feedback initially. I could get remands, that would tell me if I did something wrong, but that was usually on a denial. I wasn't receiving ongoing feedback on the favorables. Now with the quality, the Division of Quality, we're providing that information to our judges, and we're actually providing it to them now in real time. We created an electronic tool where they can go in daily and see what the Appeals Council has seen on their cases. And we're also providing information. We're working on developing a training tool for them that when they see that they've made an error according to the Appeals Council, either a remand or a decision by the Appeals Council, there's going to be, they can click on a link and get a summary of what the policy is and examples of how they should apply that policy, how it's applied in real life. So these are the things we're trying to give back, to the judges, that feedback on an ongoing basis. And we really believe most of our judges will self-correct if they get that information.
Do you all know by judge error rate in terms of compliance with the rules?
I'm going to defer to Judge Jonas.
Senator, we have, as I mentioned earlier, in our denial reviews, so say over 100,000 each year, we have information about the mistakes or the errors or the concerns, the policy issues, and certainly have that available. And the point I think with Judge Bice was making about individual accountability. So there's sort of a national approach that we've been using for training that I summarized in my testimony about using data, specific data, that it's not anecdotal anymore. So an ALJ knows that these are the issues that they're having. So we have a national approach to provide that information so that it's consistent to the ALJs and to the senior attorneys so that they're informed about that. And at the local level, they've got the tool that Judge Bice was discussing. But these are complicated. I think you addressed this during your opening, that these are complicated rules. People work very hard. We think that most people who come to work want to do a good job, whether you're at the DDS or at the ALJ level. So we have got a lot of information. They have a record to review. We want to give them tools that they can use to assist them and do this, not just to make them more effective, but also efficient in doing what they're doing. So one of the tools that we've been developing, I discussed it in my testimony at the Appeals Council level, developing a policy-compliant tool for analyzing cases. We're developing a policy-compliant tool for the judges to use at the hearings level. Do you want?
In fact, it's an electronic bench book, and we've been training on it in this last month, and this is going to be a policy-compliant electronic tool to help the judge in the adjudication of their claim. And for instance, one example would be when the judge gets to the step on the listing. In this electronic tool, it will actually bring up the most current section of that listing and the specific areas that must be met in the electronic record, and then we go through that, and it helps the judge make sure that they're making a correct decision at that level.
You discussed the difficulty and the time constraints and the Merit Review Board of taking and terminating a judge who's non-compliant. I think your figure was $1 million was
Yes.
what the cost. 3 cases wrongly decided is $1 million on average. Mm-hmm. And when you have an ALJ that's an outlier, mm-hmm. And let me state, the vast majority are wonderful public servants. There's no complaint there.